I want to talk about yesterday. The National Assembly adopted something called Bill 96, the controversial new French language law. Critics say it's an attack on allophones, anglophones, and Indigenous communities. The Quebec government says it's a way to protect the French language. They are using the notwithstanding clause so it can't have a charter challenge. It will limit the use of English in court and public services, make French more prominent in business operations of 25 and under. It will restrict any other language in healthcare, cap the number of students who can attend English language schools. There's a snitch line, essentially, and there's a search and seizure. Basically, the language police can come in and search and seize with no warrant if someone snitches that they're using English. Will the federal government challenge this in the Supreme Court, and how soon?
Well, look, as I said today in a press conference, we will defend our areas of jurisdiction. We are watching this carefully because you have mentioned a number of different fears that have been raised by experts, by me today and others. Will it affect the rights that Quebecers have to court proceedings in English, for example? Will it affect First Nations? There have been concerns raised by First Nations leadership across Quebec, the search and seizure provisions, and the protecting of the whole with the notwithstanding clause. And I'll come back to that in a second. But we've raised those concerns. But the question is going to be the implementation. It isn't on its face necessarily the case that the whatever is done will have an impact. It depends. The devil will be in the details, and the devil will be in the implementation. So what I have said today is we're going to keep our options open on the table as we watch carefully how the law is implemented. We will be vigilant about protecting areas of federal jurisdiction and protecting the rights of Canadians in Section 133 of the Constitution.
But by waiting, I know I got a minute here, but if you're not going to challenge it, if you're going to wait, aren't you abandoning Quebecers who are living under these controversial laws? Well, it wends its way to the court, saying we're going to protect people, but the devil's in the details. It's past, sir. You know the details already.
No, that's not true, Evan. We have to see how it's implemented. And until that time, we can't tell. There may be ways to implement this that don't offend the rights that Quebecers have, for example, in the courts. Obviously, we're very concerned about the preemptive use of the notwithstanding clause. I announced today that when the Bill 21 case, if and when the Bill 21 case gets to the Supreme Court, the federal government will be there. It will be de facto a national issue. And we will raise arguments about the preemptive use of the notwithstanding clause. So we are there, but everything in its time and everything in a way that we can best put forward arguments in order to better protect the rights of Quebecers in this particular case, but also to protect the charter rights of Canadians.
Well, it's going to be difficult to protect the charter rights when the province has once again used the notwithstanding clause, making that a long and complicated fight. Unfortunately, I got to leave it there. I hope we have this discussion as we see how this unfolds. Again, Justice Minister David Lametti, thank you, sir. Appreciate it.
Thank you, Evan. Happy to come back in the future.